Welcome to this deep dive. We're unpacking a whole load of sources you sent our way this time,
hmm
and it looks like you've been digging into some really, well, vital and pretty complex stuff. Mental health, mental capacity, human rights law here in the
Yeah,
UK.
there's a lot in there. Case law,
Yeah,
government reports. They're quite the mix.
it really is. So our mission, basically, is to try and pull out the key insights from all of this for you.
It's definitely, well, fascinating stuff, though it can be challenging. You've gathered a really comprehensive set.
So we're not just describing the laws.
No, no. We want to kind of connect the dots, highlight what's really crucial about how society handles these sensitive areas.
Exactly, because understanding this, it's not just for lawyers, is it?
Not at all.
It's fundamental for anyone thinking about how we sort of balance individual rights and needs, especially for people with mental health challenges or those lacking capacity.
Yeah, the tensions, the safeguards, the push to improve things.
That's what we'll explore. So, shall we dive in? You flagged the Mental Health Act and detention as a big one.
Yeah, the MHA. That's the key legislation across the UK. Really, England, Wales, Scotland, Northern Ireland. Its main job is treating mental disorders.
And using compulsion if needed.
Yes, that's the often debated part. Using compulsion when necessary, but always aiming to minimize risk.
Okay, so focusing on England and Wales, what actually needs to happen for someone to be detained under the MHA? What are the conditions?
Right, there are specific criteria. First, there has to be a mental disorder, one that warrants treatment in hospital.
Okay.
Second, detention has to be necessary for their health, their safety, or, protecting other people.
Right, necessary.
Third, appropriate treatment must actually be available.
Makes sense.
And finally, you couldn't provide that necessary care without detaining them. It's quite a high bar, or it's designed to be.
It sounds like it should be. But once someone is detained, what about reviews? What safety nets are there?
Oh, absolutely, there are safeguards. Crucially, in England, you have the first-tier tribunals, the mental health tribunal.
Right.
They can actually discharge a patient if they decide the detention criteria aren't met anymore.
Okay, so a proper check.
Yeah, and hospital managers also review detentions regularly. Plus, the nearest relative has a potential power to order discharge too.
Potential power.
Well, yes, it's not absolute. It can be overridden if there are serious safety concerns.
I see. That's reassuring, having those checks. But one thing your sources really highlight is this trend. Increasing detentions in England.
Yeah, that report, Understanding Increasing Rates of Detention, it paints quite a picture.
How big an increase are we talking?
Well, the numbers are pretty stark. It went from around, 24,500 detentions in England in 88, 89
Okay.
to over 63,000 by 2015-16. But the really striking thing is the rate of detention relative to population size. That more than doubled.
Doubled. Wow.
And the steepest rise was actually in the last decade of that period. It puts the UK quite high up internationally in terms of rising detention rates.
That's huge. Does the report suggest why this might be happening?
It does, yeah. It points to a whole range of potential factors. Maybe fewer people are coming into hospital voluntarily, so those who do are more unwell.
Possibly.
Or perhaps clinicians' thresholds for using compulsion have changed. Increased substance use among those admitted is mentioned too.
Okay.
Also, more police use of Section 136, that power to take someone from a public place to safety, leading to more formal detentions later.
Right. That immediate crisis intervention.
Exactly. But it also floats other ideas, like maybe we're just better at detecting cases now. Or the impact of deinstitutionalization, moving away from the old long-stay hospitals. Even how the Human Rights Act is interpreted regarding deprivation of liberty could be playing a part. It's complex.
It really sounds like a tangled web. And just quickly, you mentioned Section 136. Yeah. Another source mentions Section 5.4. What's that one?
Section 5.4. That's a very specific short-term emergency power. It lets a mental health or learning disability nurse detain a voluntary patient who's already in hospital.
For how long?
Just up to 6 hours. It's basically a holding power if a doctor isn't immediately available for a Section 5.2 assessment, but the nurse is worried the patient might leave and be at risk.
Okay, so a temporary stopgap.
Exactly. Can't be extended, doesn't authorize treatment without consent, and you can't transfer the patient under it. Very specific use.
Got it. Okay, so that covers the MHA basics. Let's switch gears to the Mental Capacity Act, the MCA in England and Wales, and this core idea of best interests.
Right, the MCA 2005.
Hmm.
This is really the foundation for decision-making when an adult lacks the capacity to make a particular decision themselves.
And its philosophy is quite different, isn't it?
Very much so. It's all about empowerment first, maximizing whatever capacity the person does have. And if a decision has to be made for them, it must be in their best interests and the least restrictive option possible.
So, best interests. That's the absolute cornerstone. How does the Act define that? What does it mean in practice?
Well, there's a checklist in the Act. Decision makers have to consider the person's own wishes, feelings, values, beliefs, what they would likely have wanted if they could decide.
So trying to stand in their shoes.
Pretty much. And you have to consult with people close to them, family, carers. And crucially, the decision can never be motivated by a desire to bring about the person's death, even if it seems compassionate. That's absolutely forbidden.
That's a vital distinction. And where does the Court of Protection fit in?
The Court of Protection can make these decisions legally when someone lacks capacity, but its role, fundamentally, is to do what the person could have done for themselves if they had capacity.
So his powers aren't greater.
No. For instance, the court can't refuse basic care like keeping someone warm or clean. It mirrors the individual's own limitations, in a way.
And the MCA also brought in advanced decisions, or ACDs, to refuse treatment.
Yes. Advanced decisions to refuse treatment. These allow someone with capacity to make a legally binding refusal of specific treatments for a future time when they might lack capacity.
And they are legally binding.
If they're valid and applicable to the situation, meaning they meet the Act's requirements, yes, they have the same force as a refusal from someone with capacity right now. It's a key part of respecting autonomy.
Okay. Now, another really tricky area you've flagged is deprivation of liberty. How does that differ from just, say, restricting someone's movements?
It's a difference of degree, really. Article 5 of the European Convention on Human Rights protects liberty. The courts have said deprivation is more intense, more significant than just a restriction.
Right. And the case, Surrey County Council VP, seems critical here. What did that establish?
It really clarified things. The Supreme Court said you look for key signs. Is the person under continuous supervision and control? Are they free to leave? And, crucially, do they lack the capacity to consent to these arrangements?
Regardless of whether they seem okay with it.
Exactly. The court rejected this idea of relative normality, like comparing them to others with similar needs. And it stressed that just because someone doesn't object doesn't mean it's not a deprivation if they can't legally consent. The objective facts matter.
So it's about the reality of their situation. And this led to the deprivation of liberty safeguards, DoLS.
Well, DoLS actually came about because of an earlier European court case, HL v. United Kingdom. That case highlighted that people lacking capacity in hospitals or care homes had no proper legal process to authorize their confinement, potentially breaching Article 5. So DoLS were added into the MCA to provide that authorization process. Surrey VP then massively widened the scope of who was considered deprived of liberty, leading to a huge increase in DoLS applications.
Okay, so HL prompted DoLS, and Surrey expanded its application. Got it. Let's shift to human rights more broadly, specifically Article 2, the right to life. How does that play out in mental health care?
Article 2 isn't just about the state not killing people. It includes a positive obligation to protect life, meaning the state needs a legal framework to safeguard life generally. But also, there's an operational duty established in Osman v. United Kingdom to take preventative steps if authorities know, or opt to know, of a real and immediate risk to someone's life.
And does this apply to suicide risk for psychiatric patients? Even voluntary ones?
Yes, absolutely. The Rabone case, Rabone v. Penn Care NHS Trust, was huge here. It confirmed that this operational duty under Article 2 can apply to informal, voluntary patients known to be at high risk of suicide if the hospital has assumed responsibility for their care.
So the hospital has a duty to take reasonable steps to prevent it.
Exactly. The Supreme Court said the vulnerability of the patient and the hospital's control over their environment creates that duty. The earlier Savage case also dealt with this operational duty in hospital settings for detained patients, too.
Okay, so that duty is quite broad. Now, thinking about treatment itself, being detained under the MHA doesn't automatically mean you can be treated against your will, does it?
No, absolutely not. That's a common misconception. Detention and treatment are separate, legally speaking. Part 4 of the MHA is what governs compulsory treatment specifically for the mental disorder.
And Section 63 says the treatment must be for the mental disorder.
Precisely. You can't use Part 4 to treat unrelated physical conditions without consent, generally speaking.
Are there extra safeguards for certain types of treatment?
Yes, definitely. Sections 57 and 58 are key. Section 57 covers really serious, often irreversible treatments like psychosurgery. It requires the patient's consent, if they have capacity, and approval from a panel, including a SSO, a second opinion appointed doctor.
SOA.
Yes, an independent psychiatrist appointed to give a second opinion. Section 58 covers things like electroconvulsive therapy, ECT, or longer-term medication plans. Here, you need either the patient's certified consent, or if they lack capacity and refuse, a SOSOID must certify the treatment is appropriate after consulting others involved in the care.
So layers of checks for more significant treatments. What if an adult just lacks capacity to consent to any necessary treatment, even physical?
That's where the common law principle, confirmed in the case In Re F, comes in. It established that necessary treatment can be given lawfully in the best interests of an adult lacking capacity. This is now enshrined in Section 5 of the Mental Capacity Act.
And does that apply to life-sustaining treatment too?
Yes. The Aintree v. James case reinforced that decisions about life-sustaining treatment for those without capacity must be based purely on their best interests. Again, never motivated by a desire to hasten death.
Right. And there was a specific case about withdrawing clinically assisted nutrition and hydration, NHS Trust VY.
Yes, that was important. It clarified that you don't always have to go to court to withdraw CNH from someone in a prolonged disorder of consciousness, provided the clinical team and the family all agree it's no longer in the person's best interests. It removed a perceived mandatory requirement for court approval in every single case like that.
Okay, a significant clarification for a very difficult area. Now, changing tacks slightly, that Montgomery case, Montgomery v. Lanarkshire Health Board, that really shook things up regarding consent and information, didn't it?
It really did. It shifted the focus dramatically. Before Montgomery, the test for what risks a doctor should disclose was often based on what a responsible body of medical opinion would do the Bolam test.
Yeah, now.
Now, Montgomery says the doctor has a duty to take reasonable care to ensure the patient knows about any material risks of a proposed treatment and any reasonable alternatives.
Material risks, meaning?
A risk is material if a reasonable person in the patient's position would likely attach significance to it, or if the doctor knows, or should reasonably know, that this particular patient would attach significance to it. It's much more patient-focused. It's about dialogue.
A really significant shift towards shared decision-making.
Okay.
Let's talk about the nearest relative under the MHA. The sources suggest there are issues there.
Yes, quite a few. The Law Commission, among others, pointed out problems. The main one is that the person who legally qualifies as the nearest relative under the Act's rules isn't always the person most involved or the person the patient would actually choose. Well, the rules are based on a strict hierarchy: spouse, then child, then parent, etc. It doesn't account for estranged relationships or situations where, say, a close friend or partner is actually the main carer and confidant, but doesn't fit the legal definition.
So the reforms propose changing this.
Yes, the plan in the Vitalizing the Mental Health Act report is to replace the nearest relative role with a nominated person, or NP.
Nominated person.
Exactly. The idea is that the patient chooses someone they trust to fulfill that role, to be consulted, receive information, exercise certain rights like applying for discharge, giving the patient the choice.
And if they can't choose someone?
There's a proposal for appointing an interim nominated person if someone lacks capacity to nominate and hasn't already done so.
That sounds much more person-centered. This modernizing report, it seems to put a lot of weight on service user experience generally.
Hugely so. It stated right up front that user experience was central. And frankly, some of the findings are quite stark.
Such as?
Well, a very low percentage of survey respondents felt treated with dignity and respect. There's this disconnect noted between how staff think care is being delivered and how patients actually experience it. Concerns being dismissed, that kind of thing.
That's really concerning. Does it address inequalities too?
Mm-hmm.
Particularly racial disparities?
Yes, it tackles that head-on. It acknowledges the negative experiences faced by people from ethnic minority communities and proposes specific frameworks to address this.
What frameworks?
The Patient and Carer Race Equality Framework, PCREF, and Organizational Competence Frameworks, or OCFs. The aim is to push providers to actively improve access, experience, and outcomes for ethnic minority patients by promoting culturally appropriate care and tackling systemic bias.
That feels incredibly important. Okay, let's dig into some more of the specific reform proposals in that report. Choice and autonomy seem to be recurring themes.
Absolutely central. A core principle is making sure the patient's voice is heard louder and carries more weight, even when they're detained.
How would that work?
Things like strengthening advanced choice documents, making it clearer how they should be considered, including by tribunals, making it harder to override the patient's stated preferences.
Even if they currently lack capacity.
Yes. There's a push for enhanced supported decision-making, giving people the support they need to make their own choices as much as possible, rather than just jumping to a best interests decision.
What about advocacy? IMHAs.
Big changes proposed there, widening access to independent mental health advocates to basically all inpatients, including informal ones, and people in prison waiting for transfer.
And making it opt out.
Exactly. So you get an IMHA automatically unless you refuse. And their role would expand too, helping with care planning, advanced choices.
Yeah, and care and treatment plans.
They want to make those statutory, legally required with clear timescales for creation and review to ensure proper planning for care during admission and for discharge.
You mentioned tribunals earlier. Are there proposed changes to accessing them?
Yes. Alongside getting rid of the less formal hospital manager hearings, the idea is to strengthen tribunal access. Patients get a right to appeal once per detention period.
And automatic referrals.
Potentially, yes. If a patient hasn't appealed within a set time, or if a SOA or the CQC spots a significant change, they could trigger a tribunal referral. It's about more proactive reviews.
Creating more safety nets. The report mentions ward environments too.
Yeah, just acknowledging that current building regulations might not always be ideal for creating truly therapeutic mental health wards. It suggests reviewing those requirements with input from patients and carers.
Makes sense. The environment matters hugely. What about data?
Big focus on improving data collection, especially on ethnicity. The current data makes it hard to track disparities properly, so better recording of ethnicity and MHA use at every stage is recommended.
Crucial for tackling inequality. What about younger people, 16 and 17-year-olds?
The proposal is generally to treat them like adults for MHA detention and consent purposes, so if they have capacity, their decision counts, even if parents disagree.
But parents would still be involved.
Oh yes, consulted. Their views considered, but no parental veto over a capable young person's decision. And also clarifying that any child or young person in a mental health unit is a child in need under the Children Act, ensuring access to local authority support.
That clarifies their rights. Anything else major from the reforms?
Yeah.
Care and treatment reviews. People with autism or learning disabilities.
Yes, making care and treatment reviews statutory, so they have legal force.
Yeah.
And much better data monitoring specifically for people with autism and learning disabilities who are detained because they're often disproportionately affected.
And police cells.
Continuing the push to eliminate their use entirely as places of safety for mental health crises. Plus, recommendations for more digitization of MHA paperwork, better communication between agencies, and exploring quality improvement methods within the MHA system, and looking at how treatment refusals are handled.
It's a huge raft of proposed changes, really trying to modernize things. Now, stepping back again, some sources mention merging the MHA and MCA entirely.
Yeah, that's a debate that's been around. Baroness Hale, for example, has argued for it. She points to the complexity of having two big laws, two codes of practice, often applying to the same person.
Leading to confusion.
Potentially, yeah. And lots of case law trying to iron out the overlaps. Some look at systems like Ireland's, which has tried to create a more unified capacity-based law covering mental health interventions too. The argument is it could be more coherent, maybe based on more consistent principles.
But presumably complex to actually implement.
Hugely complex, yes. There are arguments against, too, about losing the specific safeguards or focus of each act. It's a big structural question.
Okay. And finally, zooming right out, some sources touch on the wider societal picture.
Yes, briefly. One mentions Summers' model of society-state, market, civil society, and suggests that the rise of market fundamentalism, or neoliberalism, might impact the social state and potentially increase mental distress through inequality and instability.
Connecting mental health to economics and social structures.
Exactly, and the idea of social capital resources derived from social networks is linked to how social and historical inequalities can impact mental health outcomes.
It's a reminder it's not just clinical, is it?
Definitely not. And other points flagged were the higher rates of mental health issues among people with learning disabilities.
Right.
and also the fundamental importance of early childhood. The Faculty of Public Health really stresses how crucial positive parenting and early years support are for preventing later mental illness, tackling things like parental mental illness or substance misuse early on.
It really is multifaceted.
Yeah.
So we've covered a lot today. The legal frameworks, MHA, OCA, DoLS, the human rights angle, Article 2, Article 5, and this big push for reform, trying to make it more modern, more person-centered.
Yeah, and hopefully unpacking it helps people engage with these discussions. They're about real lives, individual rights, societal responsibility. The intersection of law and lived experience is, well, it's profound.
It really is. So maybe a final thought for listeners to chew on. When you're looking at these laws, trying to balance protecting vulnerable people with upholding their autonomy, their right to choose, what's the most critical element? Is it safety above all, or is it self-determination?
It's that constant balancing act, isn't it? There's rarely an easy answer.
Definitely not. And thinking about these things, engaging with these ideas, that's part of how things evolve. Thanks for joining us on this deep dive.